What is up, guys, and welcome back to another Crypto with Leo YouTube video. As you can see on screen, we're going to be talking through a Ripple vs. SEC lawsuit update today. That being because we have just seen Ripple take a major W, a major victory in regards to a recent decision made by Judge Torres. Now, I have spoken about her previously in recent lawsuit updates, and she really has come back and just started making some absolutely killer decisions, which is awesome to see, as the case was getting relatively stagnant during the expert discovery phase. But obviously, with that being over now, damn, it is getting exciting. So without further ado, guys, let's jump over here and dive straight into it. To give you a brief overview first, though, what I'm going to do, I'm going to give you an insight into what they've actually won, why it's important to the case, take you through the filing briefly as well, and then, of course, give you a breakdown of everything to expect, what we're still waiting for in this lawsuit, and how, as you'll see from the end, guys, the pressure is only continuing to build and build on the SEC's shoulders. And between me and you guys, I'm not a big speculative guy. You know, I very much just like to go by the facts and what's in front of me. But damn, it's not looking good for the SEC. You know, we've seen Gensler come out recently saying that, you know, the SEC are open to taking some losses. You know, we're seeing Brad Garlinghouse do a ton of PR at the moment. The executive order spoke about cross-border payments. Furthermore, just fully supported the building of or putting some clarity into the space of digital assets. And one of the most insane ones, we saw Jay Clayton, the person that pretty much made this whole case around Ripple before running off and leaving the SEC, come out saying that digital assets are not going anywhere and they have a future. They are not, like, they have a future place in the US. So absolutely insane stuff, guys. I personally, like I said, not a big speculative guy. I don't see this going on for much longer. That's just between me and you. And literally, I expect this to get a few hundred views. So that's why I'm just saying it's between me and you guys. So let's dive straight into it, guys. Brad Garlinghouse, or at least you're probably wondering, what is this update that has Brad Garlinghouse, the CEO of Ripple, coming out on Twitter saying, if you weren't paying attention then, you most definitely should be now. What a huge win for Ripple today. Furthermore, we also had Ripple's general counsel coming out saying that they've just taken a massive W, saying today's order makes it clear there's a serious question whether the SEC ever provided Ripple with fair notice that its distributions of XRP since 2013 would ever be prohibited under the securities laws. And then he says, good to see the judge rejecting the SEC's attempt to prevent Ripple from pursuing its fair notice defense. There you go, guys. That's pretty much outlined completely what this was. Ripple's fair notice defense, or at least the SEC's motion to strike Ripple's fair notice defense, has been denied. The judge, Mrs. Torres, or Judge Torres, sorry, has just completely denied it, and for very good reason, because SEC's arguments are absolutely, I'm not going to swear, they're rubbish. That's as simple as it gets. They are rubbish and they made no sense. And furthermore, there was no fair notice. So what's the future of it? Well, quite simply, the burden is now on the SEC to produce and actually defend themselves and saying, hey, we did give you guys fair notice. But as you're going to see later in this video, when I run through two things that were in the filing, it's not looking good for them, guys. It's not looking good for them. Now, to give you a brief overview of what fair notice is, I'll get a very good description at the end as well. In fact, no, I'll do it straight after this. Fair notice, like genuinely by definition, also can be named as fair warning. And it is the requirement that criminal statutes, in this case, it would be the SEC, define crimes with enough precision for reasonable people, that being people like you and me, to understand what activities are prohibited. And then in this is actually in the filing in itself that is actually denying the SEC's motion to strike. It says this right here: a fundamental principle in our legal system is that laws which regulate persons or entities must give fair notice of conduct that is forbidden or required. And then as we jump down here, it's pretty much outlining where they've gone back, talking about that the laws are very vague. Laws fail to comport with due process when they fail to provide a person of ordinary intelligence, that being us guys as retail investors, fail to provide a person of ordinary intelligence fair notice of what is prohibited. So basically failing to let any of us know, because let's be honest, guys, there was no clarity in the space. And as we're going to see later on, if anything, the clarity in the space was very much more on crypto's side in general after Bill Hinman's speech in 2018. But jumping back over here, guys, and there's one thing I do want to give credit to, and I don't think they're getting enough of it. I think we do need to give a round of applause to the SEC. So everyone put your hands together right now. That means because I think we're all surprised they've actually made it this far. I mean, because 96% of all SEC cases are actually settled before trial. I mean, of course, Ripple could very much still be in that 96%. But the reason I kind of want to give them a round of applause is because 90% of their cases are settled in the discovery phase. And obviously, we've just seen expert discovery phase end. So, round of applause to the SEC. You've made it this far. I feel sorry for you because you're about to take major L's, but it is what it is for you guys. Now, to understand why everyone's so happy, now we've got that out the way of congratulating the SEC, to understand why everyone is so happy, guys, and actually how important this decision was from Judge Torres, we need to understand the scale of the fair notice defense. And that is because it is so much bigger than just defending Ripple and XRP. This is literally by absolute proof that this lawsuit is bigger than just Ripple and XRP. They're fighting for the whole of crypto. And this is exactly why. If Ripple win on the fair notice defense, it will not only be significant for Ripple and XRP, but also on the crypto ecosystem as a whole. That being because, guys, that would be a part of case law that Ripple won on fair notice defense. It would be part of case law that the SEC provided absolutely no fair notice that what Ripple were doing, or any other asset for that matter, what they were doing could be classed as a security, and what they were doing was wrong. And that is why, guys, it is going to completely hinder the SEC's chances of going after any other crypto asset after this. I mean, there's one downside for Ripple winning on fair notice defense, and that is that if they do, they're not going to leave this case with the absolute clarity that we are all after, that being that, XP is not a security at all. Basically, what they'll just be leaving with is that it'll just be by default, because the SEC provided no fair notice. They never would have known they were doing anything wrong. Furthermore, Ripple have been meeting with the SEC for years, asking for some guidance and clarity, and never got it either. So they'd kind of just be let off the hook. However, it would benefit the whole of the crypto space as well. And as it says on here, guys, this is actually a pretty serious thing. It could somewhat, Ripple, on the other hand, has kept proposing new cases. Obviously, that's referencing to that. It could very much, as it says up here, a Ripple win on the fair notice, but also crypto extend and wholly even partially defund the SEC. That's what I wanted to mention. This win, fair notice defense, could partially defund the SEC. Now, I don't know the true extent or the truth of that, but it could very much put them in a very bad position because, as I just stated, they are going to find it so hard, almost impossible. Obviously, nothing's impossible, but almost impossible to go after any other crypto asset again after this, because all of them could just pull out the Ripple versus SEC case law that you guys gave no fair notice. We're in the exact same position. We had no idea what we were doing was wrong, just like none of our investors knew what they were doing was wrong. So can you explain that? And they won't be able to. Now, let's jump into the filing, guys, because there's one very important page, and I've got it written down just here. And if you guys want to check it, guys, definition of fair notice defense is on the bottom of page 6, going on to early page 7. And the next part is page 4. And I absolutely love this part, guys. I'm going to read this whole paragraph to you. On May 16th, 2017, Ripple announced that it would place 55 billion XRP in an escrow on the XRP ledger, and thereafter implemented the escrow of that XRP. However, it's this part just here, guys, that is the most important. In June 2018, the SEC, or then Director of Corporate Finance, Bill Hinman, gave a speech saying that the SEC did not consider the virtual currencies Bitcoin and Ether to be securities, and that would be put aside the fundraising that accompanied the creation of Ether and their network, and look instead at the present state of Ethereum. And obviously, now knowing what we know, now knowing the kind of conflicts of interest within Ethereum, now knowing the kind of parties, JP Morgan, that own critical infrastructure in Ethereum, it does seem strangely convenient that the SEC would just completely overlook how Ethereum actually funded the development of the Ethereum network, and instead are only going to be looking and seeing that what they're doing now cannot be classed as a security, giving them kind of somewhat full clarity, which is somewhat unheard of. But this is basically the case law, or what the kind of regulatory framework the most anyone could get hold of at the time, basically stating, oh, we'll overlook how you fundraised, and we're just going to look at the current state of your network. And that is kind of what XRP and Ripple would have been taking from it as well. So that is very interesting part of it, and that's kind of referencing to Bill Hinman's speech and the actual really simple explanation of what it meant. Now, this is the very interesting part, and this is where a lot of pressure is being put on the SEC's shoulder, and this is proof of no fair notice, or at least one is one part of proof. And that is in 2019, SEC staff met with a digital asset platform that was considering listing XRP. Now, I have a slight suspicion. I cannot remember the specific year XRP was listed on Coinbase. I do think this was Coinbase because they basically worked very closely, or in the past worked very closely with the SEC when it came to listing assets, because they always wanted to be compliant with securities laws and never wanted to mess up and list a security. And that is why when they went there, the platform sought guidance on whether the SEC considered XRP a security or not. During the meeting, the SEC did not say that it considered XRP to be a security. So you're telling me not only were Ripple meeting with the SEC for years and years, asking for some sort of regulatory guidance, some sort of clarity as to whether what they were doing was right or wrong, and they never got any. You're telling me platforms went there as well, asking for some form of guidance, asking basically whether XRP was a security and whether they can list it or not, and that the SEC did not say that they considered XRP to be a security. However, literally just a year later, they're filing a lawsuit saying, hey, but we do believe, and as it says right here, we do believe that you have been at, or the sales or distribution of XRP could be classed as security since 2013. So if they thought about that in 2013, then what changed in 2019? What changed between 2019 and 2020 when they realized, hey, wait a second, you guys have been doing this for a wrong and we've been keeping an eye on it. We just completely forgot to say it in this meeting. And that is a brief example of it just there, guys. Now, that pretty much wraps up like an overview of this filing in general and how powerful it is and how Ripple are very much in a strong position to do very well and take this very far. So understand, and I say this wholeheartedly, guys, this is extremely positive for the lawsuit. And I think it's getting to a point now, I always like to come at these from an unbiased perspective, guys, but it's getting to a point now when Ripple and XRP, they are absolutely wiping the floor with the SEC right now. So how much longer this can go on for is definitely the question. And if you guys have any idea, make sure you put down in the comments below. I want to know, how long do you guys think this case has left? And also I'd like to say, guys, if you are new to this channel, I really hope you've enjoyed this video. Make sure to click that subscribe button. And if you enjoyed this video, as I said, click that like button as well. Really helps with the algorithm, just pushing this video out. I'd also like to thank you guys. The support has been amazing recently. I've been uploading a whole lot more and I've been absolutely loving YouTube. Mainly because I just get to really speak out, do some longer form content, and connect with you guys in the comments as well, which is absolutely awesome. Now, in regards to what we can expect in the coming weeks, we still have two major decisions to be made, guys, in regards to this lawsuit just here. And that is, we're waiting to get a decision from Torres whether the 63 email chain regarding Bill Hinman's speech, whether that is going to get handed over. And trust me, guys, we very, very much want that. And then also, of course, we're waiting for the Estabrook notes, which is obviously to do with Brad Garlinghouse's and Director or Commissioner Roisman's meeting back in the day, where Commissioner Roisman basically said, hey, XRP, I do not think it's a security, but I don't really know why you're here, is what he said when he was brought in for a deposition. Now, the most important one I would say is definitely Bill Hinman's emails, obviously, because those emails are what was leading up to his speech in 2018. So they're going to be extremely important. The Estabrook notes are just as important. The positive part in regards to them is, even if they do not get handed over, even if the judge says, no, we're not going to have them, Brad can obviously still do something about that. He can still testify in regards to them, and it'll be the SEC's job. It'll be the SEC's job to prove that he was lying, which would mean, in turn, using those notes from the meeting, which is what he's asking for, to try and prove that what he's saying is a lie, which they won't be able to do because he's not lying. At least, why would he lie? If he is, fair enough, but he's not lying. The Estabrook notes, they will come out and they're going to make the SEC look like absolute. It's not going to do them any favors, put it that way. But that is if they want to take it that far. I think that pretty much wraps up everything to be expected in the coming weeks, guys, and basically gives you a very simple overview of what has just happened and why, or the implications, and why this recent update or this filing and this win for Ripple was so important. I'd like to thank you guys so much for watching. If you are still watching all the way through, thank you for watching this video. Thank you for the absolute support, the amazing support you guys have been giving me recently. I hope you enjoyed this video. If you have any video ideas or want anything covered, make sure to put it in the comments below. Have an amazing rest of your day. Peace out.